Now, if somebody said, choke me, and you thought you heard them say choke me, and then you proceed to choke them, I can understand, oh, that's a misunderstanding. I thought you were telling me to choke you, but you didn't. So I'm trying to figure out where you're coming from. All right, the court is calling 2023 CR 0684, State of Texas versus Demetric Deshaun Jackson. Can I have parties announced for the record for the state?
Travis Banks of the state of Texas.
Defense.
Lando Garza for the defendant.
All right, you entered a plea on April 19th of no contest, and you applied for probation, and you entered a plea on the offense of assault, family choking, strangulation. Punishments to be assessed at a cap of 7 years. The state opposes your application. Have both parties had a chance to review the PSI report, state? Defense?
I have, Your Honor.
All right. State, do you have any witnesses?
State has no witnesses.
Defense, any witnesses?
Just my client, Your Honor.
All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, state your name for the record.
Demetric Jackson.
All right, you can lower your hand. Defense?
Can you please state your name for the record?
Demetric Jackson.
Demetric, you've applied for probation in this case, is that correct?
Yes, sir.
Okay. Can you tell the court why you think you should be getting probation?
I'm very deserving of a second chance, and I want to be more helpful for my kids. Wow. It helped me stay more focused while I'm trying to rebuild what I lost for my kids.
Okay, this was an incident that occurred, and I believe you told me it was purely an accident, correct?
Yes, sir.
Did you have any relationship with this woman?
No, sir.
Wait a minute, I'm sorry.
Okay.
How's an, I mean, he's pled to assault choking, is that correct?
That's correct, Your Honor.
I don't understand how assault choking is accidental.
Oh, you talking to me?
Yes, I mean, because
Oh,
you're
sorry.
saying it was an
Oh.
accident. I don't know how you choke someone accidentally.
Oh, no, it was a misunderstanding. I mean, it was a misunderstanding.
How is choking someone a misunderstanding? And mind you, I'm just trying to figure out what you're trying to tell me.
Yes, ma'am.
So I don't understand how choking someone is an accident or how choking someone is a misunderstanding. Now, if somebody said, choke me, and you thought you heard them say choke me, and then you proceed to choke them, I can understand, oh, that's a misunderstanding. I thought you were telling me to choke you, but you didn't. So I'm trying to figure out where you're coming from.
I think you're referring to the whole incident. Is that
Yes,
correct?
Yes, ma'am.
You're referring to the incident, correct?
Yes, ma'am.
And did you have any kind of relationship with this woman?
No, I didn't.
Okay. How did this come about? Did she feel that she had a relationship with you, or what? Can you explain that to the court?
We was working on a business plan, and I guess our feelings got more in tune. She was trying to be more than what I was not that more. So
I'm sorry, I can't understand what you're saying.
I said, we was working on a business plan, a business deal, and I guess her feelings got more involved in. She was trying to carry on a relationship, a business relationship with him. So, I mean, I feel like she was posting her son, like, I mean,
And if the court puts you on probation, how do you think this will help you and help your family?
it allowed me to rebuild what was taken away from me, what was like literally robbed from me. So, it's the steps I have to take. I mean, for me to be out here with my kids. I mean, I'll do whatever I have to take. I mean, I promise my kids that I would give them the remainder of my years. I mean, rebuild attention to them than what I've given them in the past.
No further questions.
So you said that this was all a misunderstanding, and I was reading in the PSI that you also said she did it to herself. Did you recall telling the PSI person that she did the choking to herself?
Yes, I didn't touch it. I mean,
Okay, so it's your position that she choked herself.
yes,
Okay. And you told the TAP evaluation officer that you smoke 8 blunts on a daily basis. Do you recall telling them that?
I used to,
Do you still smoke 8 blunts on a daily basis?
no, sir.
Okay. And do you think you have a drug problem or need drug treatment?
No, sir.
Okay. And have you been on probation before?
Yes, sir.
Have you always completed your probation successfully?
Yes, sir.
Okay, so you've never had to have your probation extended?
I was on probation one time, I don't think so.
You've only been on probation once?
Yeah.
So were you put on probation in 1995 for assault bodily injury?
No, sir.
No?
No, sir.
So if the PSI says that you were, is that correct or incorrect?
Incorrect.
Okay, and you weren't put on probation in 2004 for possession of controlled substance PG 1 to 4 grams?
Question, no, sir.
So if the PSI says that, the PSI is wrong.
Yes, sir.
Okay, and you weren't put on probation for driving while your license was suspended in 2000?
Yes.
That was the time you were on probation?
No, it's in 1994.
Okay. So the
Never.
2000 for,
I was on parole. I was in prison for parole. I was on parole.
which year did you go to prison?
2006,
But before that, no probation?
no probation.
Okay. So you were never revoked from probation
No, sir.
before that? Okay. No further questions.
All right, any follow-up question?
No, Your Honor. Rest.
All right, the court will hear argument, state.
Your Honor, I think according to the PSI, he has been on probation many times. He's been revoked from probation many times. I think he's come to the court and he's misrepresented his criminal history. Furthermore, he's minimizing his guilt. He says that he didn't do it. He says it's a misunderstanding. He even told the PSI officer that she choked herself and that any injuries she might have had, she caused to herself. I will also point out that to the extent that defense tries to argue he had a rough upbringing, he told the PSI officer that his childhood was blessed and that he doesn't need any kind of drug treatment. He also said he doesn't see how probation is going to help him, but he'll try. I think this is someone who doesn't want probation, doesn't want the kinds of services that are available to help improve somebody's life while they're on probation. And for that reason, the state is asking that you meet the cap at 7 years.
All right, defense.
No, you can't.
All right, if he wants to say something, I'm fine with him saying something.
You want to say
Counsel.
something? Go ahead.
When he was saying about the, it wouldn't help me. I was talking about the treatment of the classes, not as for the probation. The lady had called me again yesterday from the PSI, letting me know that she was typing too fast and some of the words got mixed up. And she called me again yesterday and was asking me more questions. Because when I did my PSI, she really wasn't understanding what I was saying. Before it's what she typed on the paper.
Okay. All right, defense.
Well, Your Honor, I think this case has been going on for quite a while. He hasn't been in any further trouble, Your Honor. I think this was an incident that occurred because I think the lady thought that she had a relationship with him and he did not want to. We're asking the court to put him on probation. I believe he knows that probation will help him. He'd like to do what he can to get a job, do what he can for his family and be there for his family. So we're asking the court to place him on probation.
All right. Mr. Jackson, I want you to know, I did look at everything. I just don't think that you're a good candidate for probation. What I'm going to do is find you guilty, and the previous judge found you guilty. Going to sentence you to $500 fine, time and money run concurrent. There's an affirmative finding of family violence. There's to be no contact with Elizabeth Dahl. Take in consideration 2020 CR 2357, and I'll sentence you to 6 years in the prison. Give you credit for any time served. All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it?
Yes.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, Mr. Jackson, if you want, I can ask that you be referred to the therapeutic community. It does not increase the length of time that you're in custody, but it may be able to help you with any drug issues you may have. Do you understand? Would you like that or no?
Yes, I was trying to understand because
All right, thank you. Good luck to you. Court is calling 2023 CR 5651, State of Texas versus Shalice Schnitz. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Shannon Locke for Shalice Schnitz.
And are you Ms. Schnitz?
Yes, ma'am.
All right, the court is in receipt of a motion to modify full house arrest. State, have you had a chance to review the motion?
Previously, we did, yes.
All right, are you in agreement with the motion?
No, we're not, Your Honor.
All right, defense, do you have any witnesses?
I do, Your Honor. I have, so we're really asking for two things. We're asking that she be allowed to pick up and drop off her children from school. And then additionally, we're asking that she be allowed to participate in outpatient alcohol treatment. We have the outpatient alcohol treatment provider here. We'd like to call him as a witness if we could.
Okay, all right, you can call whatever witness you'd like to call. All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand, state your name for the record.
My name is Richard Paul Green III.
All right, defense?
Tell us a little bit about yourself. What do you do for a living?
I am a licensed therapist specializing in chemical dependency counseling. I'm the CEO of Precision Recovery in San
All right,
Antonio.
and just not to interrupt, but I'm aware of who the gentleman is. So if you want to
Can you
move past that, you
Sure.
can. If not, state if you want him to go into his credentials, you can.
That's all right.
All right,
Thank you, Your Honor. Can you describe the program? Just briefly what we're here for.
Sure.
Ms. Schnitz is on full house arrest. And I'm asking, really, what we're all asking is how can she participate, or what kind of supervision does she need to participate in your program? And can you describe the program to the court that she has signed up for?
Yes, I can do so. Ms. Schmitz has voluntarily entered the Precision Recovery long-term treatment and monitoring program, specifically for felony DWI defendants. It's a long-term medically integrated program, which lasts 3 to 5 years. She will start with an intensive outpatient level of care, possibly partial hospitalization level of care, and then move through the program where she will see a professional at least at a minimum of once a week for the next 3 to 5 years.
Is this something that she can do? So is it more effective to be in person for those meetings or remote?
We do like to see our patients in person. We find it to be much more accurate. The monitoring part of the program is very intense. It's built on the modeled after the physician's help program and the airline pilot's HIMSS program. So it's a very high level of monitoring, and we really need to see people in person.
If the court made participating in your program a condition of bond, and Ms. Schnitz were to not complete the program, stop going, or begin using substances that were prohibited, would you be able to report that to pretrial and to the court?
We could and would report that to the court.
And what kind of monitoring can you provide in addition to right now she's on SCRIM and she's on the ignition interlock device?
So we would add to that LCMS urine drug screens weekly, randomly. We would also add a heart rate variability monitor to be worn 24/7. That shows us when there's issues with heart rate variability that the client or patient is under stress and maybe at risk of relapse. She would be on remote treatment monitoring, where we'd have our call center ready to call her. They would contact her 3 times a month regardless, but in case there's any issue. We'd be using a medical compliance device called by JerrySafe called MediTrust. That machine videotapes her compliance with her medication. She's already been prescribed naltrexone. When she's on the right therapeutic dose for naltrexone, and we'll be measuring that through laboratory tests to make sure it's at the right level, she won't get any reinforcing effects from alcohol if she did relapse on alcohol, and it will blunt the reinforcing effects of other substances as well. We'll be using a recovery app that is designed for the therapeutic courts, called Reconnect, where we can tell where she is 24/7. We can geofence her out of areas should the court or her treatment team decide to do so. We also can know whether she's attending her AA meetings, which is very important. We really strongly recommend she be present to an AA meeting at least twice a week. We can tell whether she's on time, whether she left early, and whether she's contacting people in her support group, including her Alcoholics Anonymous sponsor. That's just some of the monitoring we do. There's more than that, including outcome testing regularly.
And so could you just describe for the court what she needs to leave her house to participate in?
So she would need to leave her house to participate in Thursday night groups where we can run urinalysis weekly and check in for outcomes and for other signs and symptoms of any type of issue that would lead towards relapse, any, for lack of a better term, disruption in emotional sobriety. Beginning September 18th, the plan is to bring her into a partial hospitalization group where she would be at our clinic from 9 a.m. till 5 p.m. So she needs some travel time in there. So probably from 8:30 at least till 6. Then after that, she'll be at a level of care of intensive outpatient where we'll be seeing her Monday, Wednesday, and Thursday from 6 p.m. to 9 p.m. for 12 weeks. After that, we'll be seeing her on Mondays and Thursdays from 6 p.m. to 7:30 p.m. in what's called supportive outpatient. She will be have physician appointments with our addiction medicine physician too. That schedule I don't know at this time. He would like to see her at least one time in person, and the rest can probably be handled through video.
And can you provide these schedules to missionaries who could then provide them to pretrial in advance?
Yes, absolutely.
I have no further questions. I'll pass it.
So this program is, what type of substance is the person addicted to?
They can be addicted to anything. Most of our patients have alcohol use disorder.
So they have to admit they have an alcohol dependency, particularly in this case.
Admit it?
Yeah.
Well, yes, they come around to it eventually.
Okay.
Yeah, there's
denial.
denials usually there.
Yeah, I'm not trying to get into all the clinical things.
Yeah.
But I mean, this program is, especially in this particular case of this client of yours, it's an alcohol dependency that she has.
We don't use the term dependency anymore. We say alcohol use disorder.
Okay. I mean, change the name, but it's the same thing, right?
Yeah.
Okay. And in this particular case, so do y'all make reports? What do y'all do? Do y'all make written findings?
We can do whatever the court would like. Usually for pretrial, we provide what that pretrial officer wants. Same thing with probation.
So if, anything's discussed, it can be in a report that's sent to the judge.
Yes, anything that's relevant to the public safety or the compliance of the patient with the program.
Okay. No further questions.
Nothing further, Your Honor.
All right, I have a question. Any objections to the court asking questions?
No objection from the state, Your Honor.
No objection, Your Honor.
So you're able to do these meetings by Zoom?
We do have the capability. We'd rather not do anything other than medical follow-ups through Zoom. We definitely would like to have the first medical assessment in person. There's just certain things we need to be able to do, like palpitate the liver, et cetera, and look for physiological issues that are actually hands-on. We'd prefer to see all our patients in person. We've used Zoom in the past, and it's our belief that in person is much more effective.
All right. So the only thing that you may not be able to use, well, you do not use Zoom for, is for medical testing.
We cannot use Zoom for medical testing.
Okay.
Or
No,
laboratory testing.
I just wanted to
Yeah.
make sure.
Yeah, we can't, we have not found a way to use laboratory testing or urine drug screens or quantitative EEGs, many different medical interventions we cannot use remotely.
Okay. All right. Any other questions?
Just to follow up, Alcoholics Anonymous in a remote setting, is it as effective in a remote setting as it is in person?
In my opinion, no. It really takes being there, being in the moment and sitting with people who can relate to who you are. But Alcoholics Anonymous is very important for treatment. And there was a great meta-analysis that was published in 2020 that shows that it may be the only thing that maintains long-term sobriety. And I can provide that study for the court if you'd like to see.
I've read it. Yeah.
Thank you.
Yes.
I appreciate
I
that.
always try to keep up on all things treatment and anything really to do with the legal system. Thank you.
I really appreciate that.
Oh, you're welcome. I try. All right. Thank you. Is there anything else?
Your Honor, just argument, I suppose.
All right. Thank you.
Thank you.
I would like to ask your client a couple of questions. Is there any objection?
Well, Your Honor,
Because there are things that I need to know.
okay, and
And if I don't know them,
I understand.
then,
I understand. I guess we'll see what the question.
all right. Can you raise your right hand for me?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth? So help you God?
Yes, ma'am.
All right. You can lower your hand. State your name for the record.
Shalice Schnitz,
All right. How many children do you have?
3.
What are their ages?
I have a 22-year-old son with severe special needs, quadriplegic. I have a 15-year-old daughter, and I have a 6-year-old daughter.
All right. So who helps you with your children?
Patrick, who is my boyfriend. We've known each other for the past 10 years. He helps me, my family helps me, my mother and father, as well as some other supports.
Are they all here in Bear County?
No,
All right. So who's here in Bear County that helps you?
Patrick.
Okay. And what are the school hours for the 6-year-old? Does the 6-year-old take the bus or no?
No, ma'am, we live exactly 1 mile from the school, which is Wilderness Oak Elementary. And so we cannot obtain the bus permission for her to ride the bus because we're too close. So she has to be taken to school every morning. Drop off is between 7 and the tardy bell rings by 7:25. And then pickup is in the afternoon. The bell rings at 2:45 to start pickup. And then it just depends on how many cars and things are there to go through the line.
All right. And your 15-year-old, does the 15-year-old take the bus?
No, ma'am, she's at Reagan High School.
Mhm.
And she, their time is 8:30 to 9 to get to school. And the time that she gets out is 4:30 to 5.
So you do drop off with her?
Yes, I have split custody with her father, and we do that.
So if I were to allow you to do this thing at the clinic, how are you planning on taking the 15-year-old to school? Because the person testified that it's from 8:30 a.m. to 6 p.m. So who's going to be taking the 9-year-old? I'm sorry, the 15-year-old,
I
if
can
I
make-
were to allow that.
I can make arrangements on the special days, Your Honor.
And Your Honor,
No. Still asking questions. So what would be your arrangements for the 15-year-old during that time?
I would probably ask one of the moms that's a friend of hers that has a child that goes to that school that I'm friends with, or something like that, just on a very short-term situation.
All right. Any other questions?
Helping say, John.
You also take her early.
Oh, yes, sir. I'm sorry. I didn't think of that. Yes, sir. I absolutely could do that.
Usually if you can get, you can get them anytime after 8,
Oh, sure. Yes, yes. Yes,
and that
I'm
would allow
sorry.
you enough time to.
Yes, I'm sorry. Yes.
All right. Anything else from either side?
Nothing from the state.
All right. The court will hear argument.
Your Honor, we're hoping that you allow her to drop off and pick up her kids from school, obviously. I think the court's investigated that. I think
All right. So let's stop right there. State, do you have any objection with her being able to drop off her children?
Your Honor, just the severity of the allegations and the indictment, it's I believe a 14 count indictment of intox manslaughter, intox assault, aggravated assault, failure to stop an underage, causing to death, and failure to stop an underage, causing injury. The state would just be opposed to her driving it out.
Okay. And are you currently, well, I'm assuming she's currently driving.
No, ma'am.
she's on full house arrest, Your Honor. So to do the urinalysis, for example,
Well, no. So if she's on full house arrest, then we were here last time where the court allowed her to attend parenting night. How did she do that?
because we got specific.
No, we got permission, but how did she
Oh.
get to parenting?
Oh, Patrick was able to take me because it was after his work hours.
Okay. All
But-
right.
I'm sorry.
No, go ahead.
Do you mind if I say one more thing?
No.
Because of his work hours, he has a position at Southwest Research, which is entirely across town from our home and area. And he goes in early and he works later. So he could not manage to not be late to drop her off or not be late to work and also to pick her up because of his time involvement with work and the consideration with traffic and him driving across town. So that would leave me as the option to take and pick up.
All right. State, do you have any objections with her going if she's not driving?
No.
All right. That's what V is for.
There would be no way to take a bus. There's no bus in my area.
Mhm.
The school is 1 mile from my house.
Mhm.
And also, Your Honor, I have not been driving for over 5.5 months.
Mhm.
I have been to 30 days of full inpatient rehabilitation, which I was very successful at.
That's 30 days.
But Your Honor, I'm sorry.
No,
Okay.
you can
Then I
continue.
also did a 12-week intensive outpatient program as well. And I have been perfectly I have not had any issues after that with any testing, with anything else in that time, Your Honor. And I am very committed to my sobriety and staying clean and doing the right thing, Your Honor. That is the most important thing, and my family. And if I have to pay for transportation currently on an Uber or a Lyft, because I do not have any family or anyone else that may take me. And Your Honor, that is costing me $900 a month. And Your Honor, I have come to the limits of my financial situation. I have no retirement. I have no savings. But I'm trying very hard, but financially, I cannot afford that. I'm sorry. Thank you.
No, there's no need to apologize. I want to hear what your circumstances are so I can make an informed decision. I always tell people if there is something I'm saying, but you want to respond to it, please respond to it, because if you're quiet, guess what? I don't know. So I appreciate you telling me what your financial circumstances are. Okay. All right. Anything else from the defense of the state?
Your Honor, as far as the treatment goes, I do think that it's important that you go in person. I will tell you, Your Honor, being on full house arrest with sole custody of a child, she's probably one of the loneliest people that you will see in your court. Being a part of a group of Alcoholics Anonymous is going to be a tremendous help to her. Being part of a recovery community that was described by Mr. Green is also going to be a tremendous help to her. So we would ask that she be allowed to do those things in person. as part of her recovery and pretrial release.
All right. So it's the court's understanding, and correct me if I'm wrong, State, you have no objections with her attending treatment, no objections with her doing drop off, but you do not want her driving.
That's correct, Judge.
All right. So the court will allow you to attend all the treatment. The court will allow you to drop off and pick up your children, but you are not allowed to drive. Is there anything else?
Nothing from the state.
Can we, Your Honor, then get the ignition interlock device removed from her vehicle, because she's gonna have to give up. Right now she
It
has
to go back.
All right. If you file the motion, the court will hear it.
a separate hearing on that, Your Honor,
Pardon?
a separate hearing on
Yes.
that.
So I'll allow you to attend all medical appointments, all treatment appointments, all school functions. And I consider, when I say school function, I consider dropping your children off to school, picking your children up, going to their extracurricular activities. So all school functions, but there's to be no driving.
Your Honor, may I ask one question?
Sure.
May I walk to school?
Yes. Yes, you can walk,
Or ride a bike?
just no driving. State, do you have any objection to her riding a bicycle?
I can just walk. I don't have to ride a
No
bicycle.
objection to a bike, just as long as she's following the traffic laws around.
Okay. All right. Is there anything else?
For the Your Honor.
All right. Thank you.
Thank you. May we be excused?
Yes. All right. The court is calling 2022 CR 8174 State of Texas versus Robert Andrade. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense.
Raymond Martinez.
And are you Robert Andrade?
Yes,
You entered a plea on April 17th of no contest, applied for probation. You entered a plea to the lesser included offense of harassment as a Class B misdemeanor. According to the agreement, punishment is to be assessed at 2 years, and the state is recommending community supervision. Have both parties had a chance to review the PSI report?
I have, Judge.
The state has been made a copy. I have not personally reviewed it.
All right. Any objections to the PSI report?
No, Your Honor.
Judge, Mr. Andrade says that between 2011 and 2017, he was in TDC. There appears to be some cases in the history during that period of time that don't belong to him. I think it's another person with the same name with a different SID number. So if there are any cases between 2011 and 2017, we do not claim those cases.
All right. Anything you wish to say on behalf of your client?
Judge, Mr. Andrade has expressed numerous grievances in his pre-sentence investigation. I can say that I agree with most of them. We've been very frustrated with the.
Second, everyone, we are on the record. If you cannot whisper, you're going to have to stop talking and do not speak behind the court reporter. You may continue.
He's been very frustrated with the delays. Part of it was dismissals and reindictments, modifications of indictments. I will say it's not the state's fault. I think they had a complainant that was manipulating and abusing the system. Mr. Andrade at this point just wants it to be over. He has a Class B misdemeanor, which he's ultimately pled to, which carries a maximum of 6 months in the county jail. He has more than that amount of time in jail. And he has over a year on a monitor. Very difficult time on the monitor, very difficult working, very difficult getting permissions. We've been here many times on monitor issues, all for us to come down to a Class B misdemeanor. So that's why he has frustration and grievances, and I understand them. He'd like to have this be over. So grudgingly, we will accept the plea agreement and ask the court to follow.
All right. Well, I mean, grudgingly, I mean, he accepted it. I don't do the adverbs or the adjectives. He accepted it. So I do see in the PSI report that the complainant has not prepared a victim impact statement, or keeps promising that one will be done. All right, Mr. Andrade, you are employed, is that correct?
Yes, ma'am.
Okay. All right, state, anything you wish to add?
No, Your Honor, we just asked that you follow the plea agreement.
All right, then, we're gonna go off the record for a moment. The punishment that you all are at. And Mr. Andrade, can I have you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. I need you to speak up. Could you state your name?
Yes, ma'am. Robert Andrade.
All right, Mr. Andrade, you do understand that the range of punishment for this offense at most is 180 days in the Bear County Jail?
Yes, ma'am.
And you understand that in the plea bargaining agreement, the state is asking that your punishment be assessed at 180 days in the Bear County Jail. But they're recommending probation. And they're asking that your probation be for a period of 2 years. Do you understand that if your probation were revoked, the court could sentence you up to 180 days in the Bear County Jail?
Yes, ma'am.
All right, do you understand that to be the plea bargaining agreement?
But I have more than 180 days.
No, I'm just telling you what the plea bargain agreement is, and I'm trying to figure it out if you understand it. So do you understand that if for any reason you were revoked, the court could sentence you up to 180 days in the Bear County Jail? All right, and you understand that to be your plea bargain agreement?
Yes.
Okay. All right, this is what the court is going to do. The court is going to all right. My understanding from Ms. Abrams is that the complainant has called in. She says she doesn't want to make a statement, but she does want $2,300. I don't know what the $2,300 would be for, but the court is not going to impose restitution without some documentation for restitution. So we can have a hearing on the restitution amount, but the court is not opposing restitution. I will say restitution, if any, and then counsel, if restitution is given in the form of documentation and you want to contest that, we can have a hearing on that.
And Judge, just for the court's benefit, she does address that in her comments that she wants some compensation, what she calls it, I guess, for being harassed.
If I could shed some light on it, obviously this was a reduction there was a grander scheme of things that led into this case, and one of them was damage to her property, Your Honor.
Okay. All right, so court is going to sentence you to 180 days in the Bear County Jail, suspended and probated for 2 years. There's to be no contact with Heidi Coleman. Restitution, if any, to Heidi Coleman. There's an affirmative finding of family violence. The BIPP course. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. Regular UAs. Regular reporting by Zoom or in person. And probation, I'll do one field visit. And if everything is okay with that field visit, then the probation can discontinue the field visits. Probation, is there anything else he needs? Mr. Andrade, is there anything else you need from the court to be successful? All right. I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, just remain in the courtroom. Probation will go over conditions with you.
And Judge, just so that everybody's clear, is he now released from pretrial conditions, including the GPS monitoring?
State, do you have any objections to the removal of GPS?
At this time. No.
All right, can I see the phone? All right, what is happening with this case?
We're ready for trial. We're ready for trial.
Do you have all the discovery?
Today, not today, but. On a later date.
All right, do y'all have all the discovery? That's what I want to know.
Assuming I do, I would sign whatever they give me.
All right, so if you can give him the discovery acknowledgement. And has an offer been tendered?
Yes. Reject.
All right, Ms. Ferguson. Recall Ms. Soria in 2 weeks for a plea deadline date,
August when?
August 31st. August 31st will be your plea deadline date. At that time, you need to let the court know whether or not you're accepting the state's offer. After that date, the court will not consider any plea bargain agreements without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes. Yeah.
All right, once you sign the reset form, you're excused. It's always good seeing you.
Well, sometimes I say the same thing that
I like that.
I was teasing you.
I know.